Good afternoon and welcome to my final session for this part of estate and tax planning. Next week, you will be taught by the estimable Dr. Lynn May Tan, who will cover all the aspects of taxation relating to the entities and structures we've talked about, as well as other entities and structures. And that looks like fun. So, but no, genuinely, I admire anyone who is interested in tax. My favourite part of tax is the general anti-avoidance rule, which I won't bore you with, but I once sat through someone's paper in a master's course, which I thought was going to be boring, about tax law, and I came out really fascinated and a bit like a geek. So I just wanted to learn more. Anyway, so in this session, we're just going to do a bit of a quick revision of what we covered last session on relationship property, and then we're going to do an overview of relationship property entitlements upon death, contracting out and separation agreements, exceptions to equal sharing, some powers of the courts, including dispositions to trusts and companies. As I've previously flagged, this is a very complicated and developing area, so we're just going to be doing sort of a bit of a once over lightly, and anyone who wants to read much more, I can direct you to some cases and commentary. And then these are two areas where in the medium to long term, we expect that there will be changes. That changes have been recommended by the Law Commission. And so if you're, for example, looking at a medium to long term estate plan, you would need to be considering the fact that the circumstances and the law are likely to change. And to some extent, you would be, building in review or planning. So you wouldn't be saying to your client, this is now set in stone. This is exactly how it's going to be in terms of legal positions for the next 15 years or so. So in the last session, we looked at the policy, theory and principles of the Property Relationships Act. We looked at the definitions of relationships, including the difference between a marriage, civil union, de facto relationships and relationships of short duration. And we looked at the different classifications of property, including, most importantly, the difference between relationship property and separate property and debt, and the special status that is given to the family home and family chattels. And in order to sort of link these back to previous topics, as we have foreshadowed and mentioned in online sessions and also in topic notes, there is, of course, a link between this topic and the wills and intestacy topic in terms of succession to property upon death. There's that link to general property law and the classification and definition of property. And as we will sort of touch on briefly, there is a link between relationship property and trust law. And in particular, that's because many families do have family trusts, particularly families with some property or interest to protect. And a family trust is often used as an asset planning tool to avoid the provisions or the application of the Property Relationships Act. And that is entirely valid if it is done correctly. And that is the big bit, if it is done correctly. But even if it is done correctly, as we will see, there is still the possibility that that they could be sort of subject to some degree of trust busting in the future. And so no one can ever provide anyone a sort of gold-plated guarantee that the creation of a trust and the disposition of particular property into a trust will prevent any challenges on any particular grounds. Does anyone have any questions from a small group who are able to join today?
No, that's all good.
No. So someone's having quite a loud conversation just outside my window, which is a bit distracting. So hopefully they will move away soon. Anyway, so the Act applies. Okay. in 3 different situations. So it applies quite obviously when parties are alive. And there are 2 sort of subsets to that, which we will look at. So it applies when people are contracting out of the agreement, so while their relationship is still going, and it also applies when they are separating. Then also, as we'll look at under Part 8, it applies when one of the parties has died. And it also applies in other circumstances. And that could be for a variety of reasons. But for example, if you are trying to get the status of a particular piece of property decided because you wish to sort that out for a third party or a third party creditor, etc. So it can get a little bit complicated there, but for the most part, we're just looking at where the parties are alive and where one of the parties has died. So the starting point is that spouses or partners in qualifying relationships are entitled to share equally in the family home, the family chattels, and any other relationship property. So you'll remember that there's particular definitions of the family home, and that's basically the ordinary place of residence where the couples set up home, and the family chattels everything, from the furniture, the cars, and the dog, but they don't include specific work tools, or for example, the the boat, which may have been owned by the male partner if it's just a standard heterosexual relationship, and he purchased that, out of an inheritance and has always just used it for his weekends away. And any other relationship property. And we looked at all those kinds of relationship property that people might have. In a standard relationship, the relationship property that you're going to be looking at is often things like just general bank accounts, shares in companies, particularly like if you're set up a one-man sort of band company, the shares in that are relationship property potentially. KiwiSaver, those kinds of things. But note that there are provisions for where the family home has been sold, that the proceeds of that sale are to be, of course, divided equally, and they can't sort of be dissipated. And where there is no family home, which is increasingly the case for many people, then that is going to be a case where the courts are going to pay particular attention to ensuring that the other relationship property is shared equally. So the exceptions to equal sharing, as we looked at last week, for relationships of short duration, and these are treated differently depending upon if it's a marriage or a de facto relationship. And marriage and civil unions, if you read the provisions of the legislation, it goes into quite a bit of detail, but in essence, it's divided upon contributions to the relationship. For de facto relationships with short duration, you need to get over a few other hurdles. You need to show that there has been a child of the relationship, and I briefly touched on in the last session that that isn't just, necessarily a biological child of the relationship. It could be that a child that has been raised jointly by the parties. And then we have the case of, whether or not there has been a substantial contribution to the relationship. And then there's the extra threshold of serious injustice. There's also the provision to depart from equal sharing in circumstances which are considered exceptional by the court. And just a recent example of this, so this is just from a family court decision. So if you recall, when we're looking at the court hierarchy, the family court are at the bottom, but they are the workhorses of the court system in terms of the family and relationship property area. And in Waldridge and Kumari, which was a decision of last year, you had Mr. Waldridge and Ms. Kumari, who met and married in Fiji, and when he was 70 years old and she was 40 years old. They were married for only 3 years. She came to New Zealand, but for reasons that I'm not clear about, he, I think, worked abroad or wasn't with her all the time, and so did try and argue that it was a marriage of short duration, which didn't succeed. However, it was found in the end that it was appropriate to depart from a standard 50-50 division of the property, because Mr. Waldridge had contributed 93% of the property in the relationship property pool. And so the courts decided on a 65%, 35% division. In terms of relationship property upon death, Part 8 of the Act sets out its own particular rules for this. And so there are substantially similar rules for the equal sharing and those exceptions that we looked at just before. But Part 8 is where you start with for division of relationship property upon death. And essentially, if you are in a qualifying relationship and your partner dies, then within 6 months of either the death, if it's a small estate, and we talked about small estates being those where a grant of administration is not required, or the grant of probate, then they need to decide by filling out a particular form, which needs to be appropriately witnessed, whether or not they're going to take their entitlement under the Property Relationships Act, or whether or not they are going to take what they have been left under the will or would be entitled to an intestacy. There are some slight differences, as I've noted here, between how relationship property is calculated or identified upon death, and as well compared to, for example, on separation. And the starting point here is a presumption that any property owned by the deceased at the time of their death is relationship property unless there's clear evidence to the contrary. So as just a broad sort of example of how this would work. So if you've got option A and option B, and option A is to take under the Property Relationships Act, then the first step you're going to be doing is identifying the relationship property at death. And this would include jointly owned property that otherwise passes by survivorship, and that's really important. So the surviving partner then would take half of that entire pool, or less of a share if it's a short duration relationship, and some is noted in the table that we've looked at previously. And the deceased's remaining half share then falls into the estate for distribution as per the will or intestacy, with the surviving partner's entitlement removed. So what that would look like is if the will said, you know, I leave everything to my wife, but if my wife predeceases me, then I leave it all to my children. If the wife decides to take under option A, what would then happen is the wife would get 50% of the relationship property, and the children would then share in the other 50% of the property. Also, for example, if you're looking under the rules of intestacy, and you may recall that there's that big table that sort of says, if there's a partner, then this is how it's divided up. And if there's a partner and children, this is how it's divided up. You would jump straight to, if there is no partner, but there are children, this is how it's divided up. And those children would then take that 50% share as set out in the section 77. Is that making sense?
Yeah.
Yep. Okay. Yeah. Yeah. So it's not just a case of, you know, you getting half of the stuff that you would be under option B. So option B, the first starting point is the rights of survivorship are retained. So you get to keep half the property. Oh. And then the estate only includes the property in the deceased's name at death. And then that being the estate is divided in accordance with the will or rules of intestacy, with the surviving partner taking their share as set out in the Will or Administration Act. And then you've also got on top of that, and we're not looking at it, under both options, things like the Family Protection Act can still kick in testamentary promises, but we're not going to look at that here because it can make everyone's head hurt. But just as a general example, if, for example, you did have a situation where, basically the kids from a previous relationship only got left $10,000 each, and the surviving spouse ended up by survivorship and because of the will with an estate of $1 million. And there is a rather complicated process by which the children could first apply to the courts to get the relationship property divided in their father's name, and then take that half and then argue for that division, not entirely, but to get a higher portion of that $500,000. So yeah, it can get quite complicated, and this is why there are proposals to simplify and update the law. So that's just that table, and I should have removed the next session, but that's the table there for your reference as we went to last week. Okay, so one thing so for the most part in most relationships, identifying upon separation, identifying the relationship property can be relatively straightforward, although there might be issues as to valuation, etc. What can be the case is this argument about whether or not it's actually fair to start from a 50-50 division of property and then expect a partner who may be otherwise less able to enter the workforce, for example, to have to start from that base. And this is where section 15, which relates to economic disparity, has become increasingly important. So this is where you say basically due to the division of functions within the relationship, I therefore have a lower earning capacity than my partner who I'm separated from, and therefore I believe I should get additional compensation for that. And so often, for example, cases might be where you might have you have two professionals, they meet at university where they were both studying, medicine, and they both go, start practicing medicine, but then it's decided that she's going to have children and she stays working, and she only goes back to sort of part-time and isn't able to build up that level of experience. They then separate, and he might now have his own medical practice, and she's going to have to sort of requalify. And so he's potentially, I don't know what senior doctors earn, but let's say he's able to earn $300,000 plus per year, and she might be getting $120,000 per year once she requalifies. Should she therefore be able to get some compensation for the fact that the reason she put her life on hold was the children? That's going to be considered quite differently from the courts than if a doctor meets someone who was training, I don't know, to be, or let's say she was like a trust fund child, and she never, they might have done some basic kind of qualifications, but they never sought to actually have a proper job. As soon as they were able to sort of just be a lady who lunches, they stopped working. They always had the actual opportunity to work, but then at the end of the relationship, they can't necessarily say that the cause of the economic disparity is because of the division of functions. It's because of their choices. And even before the beginning of the relationship, that person had made choices about their qualification and job path. So the courts are going to be looking at all of those different things and making a decision about economic disparity. And to add further complications for that, there's no set agreement as to how you're going to calculate that disparity in terms of how long should, how many years into the future should it be looking at and projecting that loss of income? How do you calculate how much of that disparity in income is due to the division of functions versus personal choice, etc.? how do you come up with a theoretical figure about what this person would have been able to earn but for the relationship? And so that's where actuaries and accountants, etc., come in. So that might be one of the things that you guys might end up doing in your jobs if you find that interesting. There are sort of specialists who just focus on that and will provide sort of basically reports for the parties and for the courts to base their calculations on. Any questions? So, Gina?
No, I just said I'm okay.
It's all good. Okay, so there are a number of other awards that can be sought, and some of those we won't go into too much detail, for example, but they make sense when you think about it. So there's orders where one spouse sort of says they contributed to the increase in value of separate property. And that could be, you know, a company that the other person owns, which could be classified as separate property, but they've somehow, you know, contributed to that company, or they've improved someone's holiday home, etc., etc. There's a possibility of an adjustment where each spouse, it's supposed to be or partner, owned a home at the date of the relationship began, to address the situation that, you know, if you decide to move, you've both got houses, and you decide to move in together, then one party shouldn't necessarily be held, you know, at a disadvantage because that house then becomes classified as a family home, while the other person might have been able to continue to rent out their home for and get an income for that. What's noteworthy with Section 18A is, although it's entitled Effective Misconduct of Spouses or Partners, I seem to, the F and the R aren't that close on the keyboard, so I don't know what's going on there. Essentially, they say misconduct isn't relevant here, a bit like the no-fault divorce system. But that also means that even in situations where you say there's been family violence, etc., the misconduct is generally not going to affect the division of the relationship property in this way. It could, in some circumstances, be taken into consideration for economic disparity as to why a spouse isn't in the position to seek work. It could also be looked at for spousal maintenance, which I touch on in the notes but haven't put here. So spousal maintenance is actually a weekly payment that is for more or less the same reasons as the economic disparity claim, but it's the payment until people can get basically on their feet again and start supporting themselves. And again, calculation of that can be quite interesting, and it's based on the standard of living that they were accustomed to at the time that they separated. For this is spousal maintenance, so that, for example, if you were living the high life in, I don't know, Remuera, and your husband kicks you out of the palatial $4 million house, and you are no longer have any money to support yourself, it's not enough for the husband to say, that's kicked you out, to say you can actually just go down to work and income to support yourself. That person who's been kicked out actually is entitled to expect that they could actually rent quite a nice house and continue to get, you know, their hair done and buy some new clothes, etc. The 18B, which is just called compensation for contributions made after separation, is in fact used often to seek what's called occupation rent. So again, that would be the situation, if we go back to what I was just talking about, when the husband is able to stay in the fancy house and the other person might have to rent a sort of less palatial house, then the husband will owe occupation rent to the estranged wife for the period until the relationship property is divided, which notionally is the market rate of the rent divided by half for the period that you were separated for. And the compensation for dissipation of relationship property, in the case of Little and Little, this was just quite a small fry relationship property dispute, but she was able to, Mrs. Little was able to successfully argue that Mr. Little, in the period of separation, had deliberately let the house fall into disrepair, and that had reduced the value of the property, or at least meant that it needed more maintenance before it could be sold, etc. So relationship property and creditors. So although there is a distinguishment between relationship property, relationship debt and personal debt, that that applies only internally to the relationship. So you cannot argue, for example, that a particular debt is a person, a relationship debt or personal debt with a creditor. The creditor is entitled just to take and say, X signed a piece of paper that says that, that he owes me X amount of money and this property is secured against that. The creditor, might, in order to avoid headaches, check who owns what, but they don't have to figure out or understand the internal dynamics of that relationship and what might be classified as personal debt and what might be classified as relationship debt. So that's the starting point. But in order to sort of balance out the potentially negative effect of that, the Act does provide for a certain protected interest, which is in the family home, the proceeds of the sale of the family home. And that might be, for example, if the home needed to go into mortgagee sale, etc. The property that is shared under 11B, so that's if there is no family home, but that there is other relationship property, or the property money shared with respect to the homestead. And you'll recall that the homestead is that particular area of land used for sort of household purposes that is on a wider piece of farmland. So in that case, the protected interest is $103,000, and that's the lesser of. So it's going to be usually that $103,000, which is set in regulations, or 50% of the equity of the spouses or partners in the family home. But you'll note that there's those exceptions if the debt was incurred jointly, etc., or there's those issues relating to bankruptcy. It's important to note, before we move on to contracting out agreements, that agreements or dispositions of property between spouses, which is intended to defeat creditors of either spouse, are void. So you can't enter contracting out agreement for the sole purpose of creditor avoidance, when you know that those creditors are there. It's a legitimate part of estate planning in advance, but you can't do it as a sort of reactive measure. Okay, contracting out. So although the Act in Part 6 is all called contracting out, if you were to talk to a lawyer, they would sort of divide the main two types of agreements as contracting out as for prior to or during a relationship, and then agreements under Section 21A, which are for the division of property at the end of the relationship, are called separation agreements. And they do look quite different, as you would expect. So a contracting out agreement, and we'll look at potential contents of those, are very future focused. So they're there to sort of set out, if this happens, this is how we will divide. They start from, this is the current property that we have, and this is how we want to classify it. And if this happens, then, this is how we want the property to be divided. And we may review that in time. And also, this is how, if any of us has an interest in a trust, how we want those trust interests to be dealt with. And FYI, if an agreement deals with the trust, then that needs to be ratified as well by the trustees, which is really important. And so you will see that there's a folder below the additional readings where I have there's basically two sets of agreements. One set of agreements is the model agreement. So those are the basic sort of clauses of an agreement for contracting out or separation that basically the government has said at a minimum, if you use this, you should be okay. But every sort of relationship property lawyer drafts their own, and they're constantly iterating them and stealing clauses from each other or taking inspiration. Just as a side note, right throughout law school, we are told that we should not plagiarize, and then you get into legal practice and you find that everyone's stealing each other's precedents. It's really bad. But it's considered okay, generally, if you follow a few rules. So they will always be sort of updating those agreements, and they will look quite different from the sort of those template agreements, because basically every time there's a new court case that may affect how relationship property is divided, the lawyers will tweak the agreements to possibly mitigate the risks relating to that. So an example of what that looks like is when we're looking at that economic disparity sort of situation. Most contracting out agreements will have provisions relating to, we agree that there is no economic disparity, but if there is, this is how we are going to calculate it, etc. And also at the end of the relationship, there will definitely be a provision relating to whether or not there's economic disparity agreed by the parties and how that has been calculated. So it can get quite complicated. And just as a note, there's also division of relationship property agreed upon the death of one party. And that can get approval from the court. An example of this is I was in the background to this, but it was quite a tragic situation in which we had a husband and wife who had separated, and they were in the midst of dividing their relationship property and had nearly got to the point of division. And it had been quite bitter because the husband had a new partner, etc. But then just before it was able to be all finalized, she died tragically. And so the issue was then having to sort out sort of the division of the relationship property and have that properly approved, also as well as sort of managing things relating to just general succession, etc. And it can get quite messy there. But yeah, that's an example when you might have to get the division of relationship property agreed upon the death of one party. And it could also be used, for example, if the partners were to sit in terms of that option A, option B situation. If a party said, I want to take, for example, under relationship property, and other family members were particularly unhappy about that, then the parties might actually be able to sit down around a table and effectively reach an agreement about what they think the surviving spouse, could fairly get. But that would then need to be approved by the court. So section 21 is that contracting out, and the key words here are make any agreement they think fit, and this concept of the status, ownership, and division of property. So generally speaking, an agreement relating to the status, ownership, and division of property is going to be very clear because it's been drafted by a lawyer, etc. But one example that I saw where it's not necessarily as clear was, for example, some of these agreements may have been made, an agreement that was made between a de facto couple in the 1990s, before they were able, before the de facto couples, and also this was a lesbian couple, before they was recognised and covered by the Property Relationships Act. So you had to go back and sort of look at, was that agreement that they had made an agreement relating to the status, ownership, and division of their property? Because in other provisions, the law does say that agreements reached before that date may be considered to be valid. So usually they'll be flagged, but not always. And it could also be, for example, that an agreement may be made in another jurisdiction, so another country, and the parties will be looking at whether or not that agreement could apply in New Zealand. And that will come down very much to, what is in that agreement or not. So this is the subject matter of all agreements. So it just depends on how you're structuring it and what you're going to say. So generally, if you look at an agreement, it will first state a recital. And the recital is basically lawyer speak for the background to the relationship. And why that is quite important is, for example, when we looked at things about, what is the status of the relationship? When did the relationship begin? When did the relationship end? Are there children of the relationship? Do the parties consider that there's any sort of economic disparity, etc.? That is used to set out the key facts that are agreed between the parties about the relationship. And sometimes it will be, if it's a contracting out agreement, that the parties are intending to enter a relationship, ABC, and it may also explicitly state they are not already in a de facto relationship. And so a contracting out agreement can also be used to state, we don't think we're in a de facto relationship. We don't intend to get into what is considered to be a de facto relationship. But just in case that changes, this is what we want set out. And it's quite common, for example, if you're looking at relationships later in life, where parties, in their 50s or 60s might have two houses, and they both intend to continue to retain those two houses, but they will generally live, in those houses, but they will otherwise present to the world like they are in a relationship. And each party may wish to set out that, what's mine is mine and what's yours is yours, for their own protection in the future, and also for issues relating to inheritance, and also so they can just tell their kids that it's all okay, and that, their new partner is not going to, take all their stuff. So generally in a standard agreement, you're going to state, this is what we consider the relationship property. This is what's the separate property. There's usually going to be schedules that are just listing what that property is, particularly for what is the separate property. And then they're going to talk about how the shares and property are sorted out in terms upon separation and death. And that may differ, and there'll often be, for example, review dates, and if the relationship continues for 5 years, what that looks like versus 10 years, etc. Provide for how the shares are to be calculated. So an example of what that might mean is if at the time that so A and B enter a relationship, and A's parents agree to loan them money to purchase a house, or even gift A money to purchase the house, but on the condition that, for example, $80,000 is, protected, and that they potentially get a greater share of the division of relationship property if the relationship was to end, to reflect that. So the parties will continue to, pay the mortgage and share the expenses together. The house will consider to still be classified as relationship property and the family home, but there will be a method by which it's calculated to sort of acknowledge the greater sort of contribution, often through the parents, of one partner over the other. And again, that's how the division is to take place. And some of that, for example, could be like, how are you going to sell the property? So the de facto agreement that I referred to talked about, if one party dies, then how are you going, how long should you be able to remain in the house? Or if you separate, how long should the other partner be able to remain in the house? How are you going to sell the house, or can someone stay in it, etc. So they don't need to be that prescriptive, but they could be. And they could also be, talk about, how they're going to be valued, how you might be appointing an agent, etc. In terms of when the separate agreement is at an end or the relationship is at an end, for leaving aside the complex relationships, if you just take a standard relationship where someone had, there is relationship probably as a family home, some Kiwi saver, some family chattels, etc. The reason that the parties are going to be entering in a separation agreement is often for the bank, because one party, either they will need to be selling that house or property, and then dividing up the shares of that, or more commonly, depending on the property market, one party may be wishing to buy out the other party. And so you need to sort of agree on the method by which you're going to value that property, how the, whether or not, for example, there's going to be occupation rents, all those kinds of things. Sometimes people might leave some equity in the home so the other party can pay them out over time if they might not be able to access that cash, because there can be some quite complicated sort of calculations you need to do as to how much do I need to pay my ex to pay them out, and also how much do I need to sort of satisfy the bank that I can afford in terms of a mortgage. Formalities. So this is where relationship property agreements get a little bit more complicated, because generally speaking, it's not uncommon for parties to come to their lawyer or with a draft agreement or some draft provisions. Sometimes they might have even used, and there's nothing wrong with this, some of those online agreement builders. And then all they expect their lawyer to do is say, you might want to change this. Are you really, really sure about this? I will format it for you. And then, it all gets signed. But, and there's quite a few big buts. The first thing is both parties need to get independent legal advice. And that means both parties need to see different lawyers who do not have conflicts of interest. So that means they haven't necessarily acted for the parties before. That can get quite, or it can get quite sort of difficult when, you might be going to an if you have just entered a relationship and you say we need a contracting out agreement, and you use your long-time lawyer to draft it up, and then you send the other person to a new lawyer. There's some issues there. Or if you separate and you've got a long-time law firm, who gets that lawyer to help you divide up that property? Who owns the lawyer, and should that lawyer be acting because they have access to information about both parties? And generally speaking, the good practice would be that that family shared lawyer should be sending both parties to different lawyers. The signature of each partner must be witnessed, but not only not be witnessed, the lawyer must certify that they have explained the effects and the implications of the agreement. And that's just not a sitting down and sort of rattling it off. You need to be really, really, really certain that that person understands what they're entering into. And the relationship property partner that I practiced under took these obligations very, very, very seriously. So, when she took initial instruction, she'd be writing very comprehensive letters saying, this is what you've told me, this is what, how this does or does not differ from the actual provisions or your rights under the Act. These are my suggestions, etc. They would then be working with the lawyer on the other party to make sure that they got very comprehensive disclosure and valuations. When it's just like a house and a KiwiSaver, it can be quite simple. When you're starting to talk about valuation of businesses and partnerships, that can get quite complicated. And also you'd be trying to address issues relating to the trust property and what's in the trust deed at the same time, because you need to be reading it all together. So even if the trust property is separate, for the person who is, or the people who are separating, what matters to them is what rights and interests in property in its entirety will they have at the end. So you need to think about all of that, and that also be looking at issues relating to spousal maintenance and child support, etc. And then also be looking at that future possibility of the need to pay, spousal maintenance, child support, etc. in the future. And then she would once it's all written up, she'd then provide another set of written advice saying, this is the agreement, and these are the key bits that you need to be aware of. She would then sit down and go through clause by clause with them on that agreement before she allowed them to be signed. And then she'd be taking very detailed file notes about what she told the client and what they came back. She was known to refuse to assist with certifying agreements like the few days before the wedding, or when someone had previously disclosed to her that they were suffering quite serious clinical depression and that they just wanted this, to move on with their lives. So it's not always a nice, straightforward, you take the agreement, it's going to get split. And an agreement which complies with these could still be avoided on legal equitable grounds, sort of, for example, mistake or like undue influence, duress, etc. And but even where an agreement is void, the court may give effect to it. So that might be in situations where it could be either a small thing like it hasn't been signed correctly, or it could be that it was signed in another jurisdiction and the parties thought it was all legal, and the court looks over it with a fine-tooth comb and says, actually, that's fair. It's a fair agreement. The parties were intelligent. They knew what they were doing. We're going to go ahead with that. And so even when it's all signed, the courts can set it aside for serious injustice. And that's going to be, looking at the provisions of the agreement, the length of time that has passed, because circumstances change for the parties, and it could have either been unfair or unreasonable at the time it was made, or it's just become unfair and unreasonable. But they will balance that out against the fact that the parties did, enter this agreement because they wanted to have some certainty, and any other matters that the court considers relevant. But if parties aren't able to set it aside for serious injustice, but they're still unhappy with it, they could sue their lawyer for negligence, which is one of the reasons that my supervising partner was very careful, because she did not want to be sued. So in addition to being able to go to court and say, I want the relationship property divided and maybe some orders for economic disparity, before you even get to that point of the court making those orders to divide, you need to make sure that the property is protected, and so nothing can happen to it while you're sorting this out. And so we've previously touched on the ability to put a notice of interest or notice of claim on land. Often family property, but it could be the family home, but it could be other property which you consider you just have to have an interest in, and other dispositions of property. So they could prevent you from selling a property, or putting it into a trust or giving it to someone else, etc. There's the ability to claw back and stop that, but you usually need to be quite on top of things in order to make sure that you identify that property and to stop that. And because court action is quite expensive, you'll generally only be doing this for significant pieces of property. You will not be applying to the family court for, to stop the sale of your favorite couch on Trade Me, for example. This is where we start to get to the fun part. So if we look here, so we had section 44, so that's dispositions of property can be set aside, and that includes dispositions of property to a trust. So if it's very clear that the disposition of property to a trust was effectively for the purpose of avoiding relationship property things, then section 44 applies, and you can get that set aside and clawed back. Then there is also section 44C, where if you might not be able to get the property clawed back, you could seek compensation from the trustee if you have been prejudiced by that transfer. And there are some exceptions, which include that it cannot be made when the compensation can be obtained from the spouse. So if you can, if your naughty spouse who transferred that property has sufficient funds to compensate you directly rather than by the trust, then that naughty spouse should do that. Or the third party has in good faith altered their position. So essentially that's, everyone has been honest, the trustees or another third party has been honest in those dealings and relied upon them. What's also noteworthy is we've got the section 182 of the Family Proceedings Act that's floating around, and I make a quick note about this in the topic notes. And this is another trust busting provision, which is quite controversial. And the most recent case for this is Preston and Preston, which was a New Zealand Supreme Court decision of last year. Essentially, nuptial settlements historically were those settlements where the parties, either created a trust upon marriage, or maybe the bride's parents said, particularly when women couldn't hold property, this money is for the benefit of the wife. And you could then make make agreements relating to that. Preston is taking that further, where we've actually got a marriage that was of relatively short duration. I think it was only 5 years. This case, the Prestons are infamous in the New Zealand Court of Appeal. This was called the case that ate its head off. And there were some quite pointed remarks by the judges about just the conduct of both parties overall and continuing this, because the relationship property at issue was, in perspective, quite modest. So there's been some very big sort of cases. So the Clayton decisions that we've looked at one of them relating to the Vaughan Road Property Trust, but there's some other ones that had quite significant amount of properties. This one, not so much. But in this case, Mrs. Preston was able to successfully argue that in the circumstances, even though this particular trust had been created before the marriage, the way that certain property had been managed, the fact that she was able to receive benefits from the trust while she was married, established that it was a nuptial settlement and that she had some interests in it. So it's another reason why you want to be really, really careful with this and trusts and relationship property. Only applies to married couples, not de facto couples, which is really important. And lots of people are calling for the abolishment of this section. Any questions? So there are substantially similar powers of the court relating to companies, or at least qualifying companies, where a spouse or a deceased spouse had a controlling interest, which equals 50% or more of the voting rights. And again, there's those powers of disclosure and the powers of compensation. Before I forget, just going back to those powers of disclosure, it's worth noting that those powers of disclosure for trust existed before the Trusts Act. So it'll be quite interesting to see how those two work. The Trust Act is more proactive disclosure versus this case where it's a case of disclosure in reaction to a case being taken in those. And it's also potentially disclosure where the spouse who's making or partner who's making the claim may not be a discretionary beneficiary of the trust, but may be wishing to find out what's happened to particular property that has been disposed of into that trust to avoid claims. So if you had, a wife who had a trust before the relationship, and she and her children from that previous relationship were the discretionary beneficiaries, and then the husband and wife split and the wife started disposing of property into that trust, then the husband doesn't necessarily have a beneficial interest in the trust in that he's not a discretionary beneficiary. but he may be looking to try and claw back some of those assets which have been disposed of into that, and that's why he's going to be looking for disclosure. Okay, so getting to the end, these are, so as we've previously mentioned, the Law Commission in, I think it's 2017, made significant recommendations for the change in the relationship property legislation. So the underlying principles of equal sharing and best interests of the children, and this concept that similar relationships should be treated substantively the same, all that remains, but they were looking for the most part about how can we make this more straightforward, how can we recognise the more contemporary relationships, and in particular can we recognise sort of some of the unfairness that people sort of see as happening when a party may own a home before a relationship, and then their partner moves in and that all of a sudden becomes the family home and has to be split 50-50 once they've been together 3 years. Is that fair or not? So one of the biggest proposals, more significant things for us, is that they propose that the family home should be the separate property if it was acquired before the relationship or as a gift or inheritance, but the increase in value of a separate family home during the time it is used as a family home should be relationship property. So that would potentially help, for example, in the recent economic climate, when if you got together in 2017 and now you're separating, most houses have significantly increased in value, and you would be, if the house started with 400,000, now it's worth 800,000, you would be able to share in the 400,000, and you would possibly have the $200,000 in relationship property. However, if there is no increase, or even a property relationship, the value of the family home goes down, my understanding is you don't have to share in that loss, but you're not going to get the same benefit. What's also of interest, particularly for people who are in financial planning potentially, is the idea of financial income sharing agreements, or FISAs, which are to replace things like spousal maintenance and economic disparity claims. And the proposal is that if you have a relationship of 10 years or child of the relationship, etc., then for the next 5 years after separation, you take your combined family income of both separated partners, and then you divide it between two, and each should get 50-50. There's a lot more detail, that's an oversimplification, but it is intended to provide at least a bit more certainty as to how those things should operate and how to sort of make, recognise those economic advantages and disadvantages without, having to get actuaries, etc., involved. And in terms of relationship property upon death, so this is a more recent set of recommendations from 2021, because the Law Commission has recommended that the relationship property upon death get carved out of the existing relationship property legislation and put into a new legislation on succession law. And so they suggest that you get rid of option A, option B process, and you instead have an option to apply to the court for division of relationship property within 12 months. So that's an extra 6 months, which if you're quite sort of affected by, someone's death, 6 months is quite short when you actually factor in that, you need to have the property identified and valued, and you need to be able to take advice, etc. Realistically, that means you have to potentially be sitting down with a lawyer only a few months after sort of losing a life partner and discussing their property in quite a clinical manner. If you elect to take what is now option A, that relationship property division, then the surviving partner should also still receive the gifts under the will as a starting point, and then you get a bit of a top up, and that's considered to be a bit fairer. And there's changes proposed to the classification of relationship property and of some qualifying relationships. So again, together, these proposals for relationship property and just generally in relationship property upon death are probably going to take a number of years to sort of first, get themselves sort of picked up by government and then drafted into legislation and then wind them way through Parliament. And even once that law is passed, they usually have sort of some transition periods. But what it is foreshadowing is that there is some change on the horizon. Okay, so does anyone have any questions about relationship property? I'm quite proud I covered that in about an hour.
So presumably it's best to, the reason like outlining these things that may come up in the future is something that lawyers that specialize in this would be conscious of when they're like creating some agreements and things now, because obviously if the rules change in the future, like you say, it always changes. So something written 10 years ago can be affected by the rule changes now. So is that something that you've found from your practice that they're quite conscious of?
Yeah, you're always going to sort of be advising clients that they need to update their wills frequently. Most contracting out agreements, a good one, will have a review date in it where the parties will sit down. And if you've got children, that review date might be every 3 to 5 years. Or you're relatively young. Versus if you're old, it might be every 10 years. It's just something to keep in mind with that. These rules are not usually set in stone. This is not going to be the rules forever necessarily. And so when you're planning for that, you do need a degree of flexibility in the future. And we're talking here short to long term and more likely long term. But yeah.
Yeah, cool.
Any other questions?
Me again. Oh, sorry, someone else go.
Victor, we'll go Victor first. Yeah.
So when you're saying about when the couple separate, and one of the spouse has a trust and they transfer like the property into the trust. So does the other partner, because according to like the Trust Act, he has, like, let's say if he is also a beneficiary, like according to the Trust Act, he has a right to get like any information for the trust as well. So does that still apply once they separate? That
still applies. So you'll just have multiple roles. Often I think as we've foreshadowed, trusts will often have what are called resettlement provisions, which will just talk about what is to happen upon the separation of the parties if that happens. And often it's going to be, it's not always, but often again, it's going to be the creation of 2 separate trusts with mirror provisions, and maybe it all varies, but with basically, if it's a very simple sort of family structure and it was a husband and wife and some kids, then the one trust will have wife and kids and the other one will have husband and kids as beneficiaries. Other sort of ways it could be is, within the relationship property separation agreement, one partner. So for example, if it's the wife's trust, but the husband is named as a discretionary beneficiary, then as part of the separation agreement overall, there will be some documents where the husband might give up his rights to the trust and will sign agreements basically removing himself as a beneficiary of that trust in exchange for some kind of benefit. That all needs to be, and that means you've got a number of processes where you've got the parties acting, both as beneficiaries and just general partners, and you need the trustees to sign off. So all the documentation needs to be done correctly, but it can be done, and it's quite common for the parties just to sort of pull themselves off each other's trusts, and if they are both trustees, then one might remove, etc.
Okay.
But it could also be the case that their accountants, etc., could actually say, no, you should keep the trust as it's currently operating. And you might just set out some rules as to who's going to get what. It might not actually be in the party's favour to split those trust assets at that time.
Okay.
Does that make sense?
Yeah.
I can get really, so it's just a lot of nuance and it gets tailored. Alice, do you still have a question? Anyone else have a question?
Yeah, so the thing I'm trying to understand is I get the contracting out thing, but I'm a little bit confused still about when that isn't the case. So I'll use an example. If let's say that your partner has money in a trust from like inheritance through trust, you know, from parents, grandparents, whatever, and it's decided that you're going to buy a home or land or whatever to be your family home, but from that trust, but there's not a contracting out agreement, and then you later separate, you know, 5 years, 10 years, whatever, you know, in the future. How does that work? Does it depend whether it's bought in the trust name or whether it's the money's gone to the person and then bought it? Or I'm just a little bit confused about that, because I get you can contract
quite
out.
Confusing. So if they're married, you're possibly going to be, the starting point is going to be the Section 182 and the Family Proceedings Act, and whether or not you've got some stuff there about who's the beneficiary or not, and whether or not that could be considered to be a nuptial settlement. There's also some of those things about the compensation for parties' property disposed of to a trust. So you might be looking at Section 44C, because it's disposed of to the trust. It all depends on when the relationship began or not. And then there might be some considerations about whether or not you could actually have a constructive trust and interests, etc. Any good lawyer, when a trust is going to, or trustees, if you're a trustee of a trust and you're proposing to make a sort of advance, possibly, or purchase a house on behalf of, you're going to be wanting to make sure that it's all quite well documented as to who does what, etc. And it can get quite complicated. For example, if you are, I'm looking at the time here. FYI, anyone who is still watching, who needs to go on, this is not essential. This is just general chit chat. Anyway, if you had A and B who, I'm just trying to think where I'm going. Yeah, so if you're A and B and A's trust purchases a house for them to live in, and B is not a beneficiary of that trust, then if A dies, then B technically can't remain in that property because they're not a beneficiary. And the trust, and the trust can't actually, you know, be giving a benefit.
Well, exactly. That's because that's the nature of trust ownership.
That's the nature of the trust, unless you've got it all tied up at the beginning, whereby maybe there'll be a grant of a life interest, etc., and the parties have all signed that, etc.
So is there any? Because I think what confused me was like.
It's just generally confusing, Alice.
There's lots of differences to it. No, I think what it was is that, like, for lots of people, they're obviously already for a number of years, or in fact, some people are already married, and then obviously family members pass away because that's the nature of life. And they're left with things.
If it just goes to them personally, then that's separate property unless it intermingles. So you need to separate out trusts, and there may be an existence of a trust that has given some kind of advance to a person. But again, there's intermingling versus it's a trust-owned property. So you need to remember, you know, distinguish between an advance or disposition from a trust versus what is owned as trust property. And then you also need to go, if it's a gift, if we go back to session 1, if it's relationship property, if it's separate property that comes from a disposition from a trust or an inheritance, that will remain separate property until it becomes intermingled. And one way, very common way for it to become intermingled is it's used for the purchase of a family home. And then even for paying down the mortgage of a family home.
That's what I'm.
And then it's all gone, unless you've got it all signed up and tied.
At that point, it's just equal, right? But, no, that makes sense. I mean, I appreciate that. Like, obviously, on these issues, that this is why talk to a lawyer or whatever, but I'm just trying to understand it a bit more. It's only because
no,
it's something
that's completely fine. Like I had situations where, you know, we have to actually discuss, you know, these kinds of things with beneficiaries, particularly beneficiaries of wills who are about to get significant amount of money.
yes,
So you know,
yeah,
and then file note it and say, okay, so and this, I had one estate where, you know, the kids weren't actually rich and they had to, they in the end, you know, it's more complicated than this, but they were like, gosh, we wish that dad had actually, you know, spent some of this money when we were alive so that we could have actually drunk real orange juice and had nice cereal, you know. This is just Bex and Raro our entire lives. But, you know, he dies and then he leaves these relatively young children, you know, about 500k each.
yeah,
And so you're talking this through with them and saying, FYI, you need to keep this separate. And if you're planning on buying a house together with your partner, you need to get a contracting out agreement or this is all going bye-bye.
Yeah.
And so, for example, one partner was like, actually, my husband has just, you know, cashed out of left the army, has cashed out his quite generous army super and put that towards his part of the mortgage. So I'm going to pay mine to my part of the mortgage and we're just, you know, we love each other. It's all good. They don't have to be exact, but, you know, we're each making our own contributions, don't care. While others, you need to be really careful.
Yeah, it's only become relevant because of things with my own partner. There's no issues.
No, this is really important actually, because particularly there's concepts of gift versus loan and the current property market where, you know, often people are getting into the property market for either with advances or help from the family trust or from the parents.
Yes.
And figuring out the status of those is really important. And many parents will make these things subject to relationship property agreements and contracting out agreements. Whether or not, I don't know the bank's perspective on that.
Yeah, right, yeah.
So that's one thing you've always got to keep in mind.
Yeah, I guess it's because it's something I haven't thought about that deeply until, well, because, you know, like my brother, for example, like my parents helped him with the house and so on and so forth. And I don't think they did anything necessarily to separate anything out, but
it all depends. Like if for example, you know, they're a really tight relationship and then they've got kids and all that kind of thing, you sometimes are not so great. It's going to be the case if you've got a child in their early 20s who in their first, first serious relationship decides that they're going to buy a house.
Yes, yeah, totally.
And you're like, we like this girl, we like your new partner, but we know that life happens.
Yeah, exactly.
What do we want to happen? Yeah. And this is the kind of planning, etc. What kind of structures do you need to have in place?
Yes.
And it's the thing that you're putting in with family. And when you're looking at sort of succession and estate planning, you're looking at that. And if you're also looking at, you know, particularly this multi-generational thing and these concepts of fairness between generations and between different sort of spouses, between siblings, etc. And that will vary quite a bit between, you know, culture, as in, you know, so I imagine sort of Asian, Samoan, Pacifica, Maori, you know, each culture will have slightly different ways of looking at that, but also general family culture. Each family will have very different ways. And there's no right or wrong way. You just need to do it with open eyes.
Yeah. No, that's awesome.
Okay.
Thank you.
Any other questions? Because this is our final session, so you can ask me sort of anything. And if it's stuff that you don't want recorded, just tell me by chat, and then I will do my last little.
Sorry, Michelle, I know we're a bit like over time. But
it's fine. I just, as long as I think it's the final session and I've kept our time for the most part, and I'll make it a note on the recordings that people don't have to listen right through. Yeah, you had a question?
So for the assignment, it's just for the last part. I know you explained just now, but for like the last part, we say where we need to like get more information from like the lawyers. So should I put it kind of like a question or as?
It's
like
however you want it. There's no right way of phrasing it.
Okay, so if I put it as kind of like a recommendation, like
ask for
example,
in order to learn more, we need to find out, you know, in order to provide good advice, we need to find out X and Y. Yeah.
Okay, so
it's
like
as long as I know that that's what the intention is. But yeah.
Okay, so let's say for example, like the party A should get more information from like their lawyer and stuff like that.
Yeah.
Okay. Then should at the like before the recommendation, I should just put like a small conclusion. Is that right? Or
not necessarily. It all depends on how you've structured it.
Okay. All right. Yeah, that's all. Thanks, Michelle.
No problem. Thank you to everyone. Just as a quick note, so that it is recorded, and also I'll make sure I'll update the slide so that is there. So I will aiming to get marks and feedback for assignment 1 within 15 working days, and of that being due on Friday. That I would like to emphasize the working days. The questions to me forum and my personal communication will remain open throughout the course. So, for example, if you're catching up on study over the holiday break, mid-semester break, or in just the weeks leading up to the exam, I will be available then. And there is a revision session scheduled for Friday the 3rd of June between 10 and 11 via Zoom, the usual sort of link. We will be talking about this content, and I believe that Dr. Lynn Maytan will also have her own revision session where she talks about the tax stuff. So thank you to everyone for joining me for this first section of the course. I hope you learned something and that you have found it overall sort of worthwhile. I know that there has been quite a bit of reading for some parts. I do hope to sort of review and refine those in future, but the fact is that law does involve a lot of words sometimes, but congratulations for getting through those readings. And as I said, please get in contact if you need some further help or suggestions about other readings or other questions, etc. And I wish you all the best for the future.